Welcome, everybody. It looks like we have a good turnout starting up now. And I'd like to get us going then. My name is Nelson Bonner. As you can see on the screen, I'm on the CPR Initiative Board of Directors. I'm secretary. And it's my privilege today to be the moderator for this event with Dan Galpern, who is our general counsel and the executive director of CPR Initiative. He is currently in The Hague, in Netherlands. He's going to talk about the International Court of Justice, and so why don't I get started with you. Dan, do you have some words you'd like to say before I have a few questions for you?
No, except that I'm delighted to be with you all. And Nelson, thank you for helping me run through this material. I should also say at the at the end, we will have I guess a 2-minute intermission where people can write their questions if you haven't done it along the way in the chat. And then Kaylee Martin is with us. She helps, she's our communications professional, and she will help review those and then feed them to Nelson. But as we're going along the way, Nelson's going to be helping me try to keep on track to cover all the material that we wish to do.
And let me just interject that if or when you have questions, to please submit them to Kaylee specifically, because there are three of us that are hosting. Dan's a host, I'm a co-host. Actually, Kaylee is the host. Dan and I are both co-hosts. So if you submit the questions to Kaylee specifically, that way Dan won't be distracted and I won't be distracted while he and I are doing the questions that we're going to be opening with. And then Kaylee will submit the questions or send the questions over to me, and I will present them to Dan. So after the intermission. So with that, Dan, let's get started here. First of all, can you explain for those who may not be familiar with Climate Protection and Restoration Initiative what it is and you know what our purpose is and what that has to do with going to The Hague?
Right. So this is our website. The organization's name is Climate Protection and Restoration Initiative, and the website is cprclimate.org. This will be familiar to many of you, but perhaps not to some. The organization, we founded the organization in order to figure out how do we break through the political deadlock in the United States to figure out how can we move our nation from laggard to leader by the enforcement of existing bedrock environmental and other law. And so we have pursued several initiatives. Here is just, you know, our front page and what's new and some blog items as well. But in 2022, we actually petitioned the Environmental Protection Agency to phase out greenhouse gas pollution from fossil fuels. Fossil fuels production and consumption is the predominant cause of dangerous climate change. And we are, for many reasons, we needed to bring that effort to a close, but we are in process of developing a new petition to put in front of the Trump EPA to give them the opportunity to do the right thing, and if necessary, following up beyond that, compelling them to do so through legal action. So that's what the organization aims to do, is to make a significant contribution by pressing our nation to move from a laggard to a leader in this area. And of course, there will be some significant additional challenges. And by the way, we have done a number of other things as well. We've sponsored 4 public hearings on the question, what more should the United States be doing to help resolve the climate crisis? And all of that work helps us develop a record for decision when we put this in front of first the agency and then going to court. Now, I'm in The Hague because of this remarkable proceeding before the World Court. And in particular, because in addition to my work with CPR Initiative, I run a public interest solo practice environmental law firm, and my longest standing client there is the climate scientist James Hansen, and he and I assisted a nation in its briefing to the International Court of Justice on climate change. And in fact, we submitted his expert report in this proceeding, and I'll be talking about that a little later on.
So, Dan, could you explain the difference between the World Court and the International Court of Justice, and also why the World Court decided to meet to deal with the climate crisis at this time?
This is a image photo that I took of the Palace, the Peace Palace, and it is the home. Well, it was actually created to be the home of the International Court of Arbitration. I'm sorry, the Permanent Commission on Arbitration, founded in 1899 with the first Geneva Convention. This was constructed and built by 1913. But it also houses the International Court of Justice. I should also say that International Court of Justice is the World Court. I use those terms synonymously, as do some other people as well. Most commonly, it's known as the World Court, but it's also commonly referred to as the International Court of Justice. And the International Court of Justice is the organ of the United Nations. It is the final word on what legal obligations attach to nations, what are nations required to do or not do. International law develops through custom and practice. Treaties are binding and considered part of international law, but treaties are not the net sum of international law. There are customary practices and moral norms that are also recognized as part of international law. For example, relevant to this proceeding, there is the duty the duty to allow states to continue intact. There's also a duty not to destroy or pollute the resources of your neighbor. That's a duty of prevention. There's a duty of reparation where you have injured another sovereign state. In any event, this is where it's housed. And then I want to say something about the membership. People really don't know very much about the International Court of Justice. It's a rarefied court, but there are 15 judges on the International Court of Justice. They are, unlike the United Nations, these judges are required to act independent of their nations. I mean, they can be influenced by an argument from their own nation as an argument from any other nation, but they do not represent, there is a person from the United States currently a judge on the International Court of Justice, but she is not bound or obliged in any way to vote in any particular case in favor of the position that is advanced before the court by the United States. In fact, she's required, she's duty-bound to think and act as independently as possible. So anyhow, just scrolling through. And by the way, I find this a little interesting. I don't know if people here will too, but everyone's name seems to fit their country. Not great surprise, but the President Nawaf Salam is from Lebanon. Vice President Julia Sebeltindi is from Uganda. Judge Peter Tomka is from Slovakia, and so on down the line, including the person who happens to be from the United States, Judge Sarah H. Cleveland. In any event, I found that to be a little amusing. Now, the case file. By the way, am I properly displaying this?
Yeah, and I was going to ask you what the questions are that the court has decided to take up.
Yeah, let me get to that in a second, Nelson, if I can.
Sure.
Because I just want to show the parties. There are, I think, 95 parties in this proceeding. Most of them are individual nations, but there's a few multi-nation group. For example, Denmark, Finland, Iceland, Norway, and Sweden are in it jointly, which means that they submitted a joint brief and at oral arguments. Then that's what I've been doing here for the last 2 weeks, attending the oral arguments and monitoring them. Denmark, Finland, Iceland, Norway, and Sweden presented together. Also, by the way, Vanuatu and the Melanesian Spearhead Group presented together. In addition to nations and national groupings, we have, cycling down to the last 2 days, entities, international entities, the Pacific Islands Foreign Fisheries Agency, or the Alliance of Small Island States, or the Commission of Small Island States on Climate Change and International Law, and so on. And also the Organization of African, Caribbean, and Pacific States, the World Health Organization, the European Union, and the International Union for Conservation of Nature. All of these were allowed to participate as parties in this proceeding, because the court wanted to hear from these international organizations as well as the nations. Okay. So let's see, what was your next question?
The next question is, what did the court decide to take up?
Right.
What questions?
Okay, so I have a slide on that too. I've abbreviated these questions, but to just provide the essence of it and not the complications. There were 2 questions that were submitted to the court. And I should give a little background about how this came about. It came about because the Republic of Vanuatu, a small Pacific island nation, developed a coalition and worked on a set of questions and brought these concerns to the General Assembly. The General Assembly has the authority to ask the court to undertake advisory, to issue an advisory opinion about questions that are pressing upon the international community. The General Assembly voted unanimously, because I think no nation was interested to oppose. And so these are the questions that were then submitted. These were formulated by Vanuatu. There was not, I think, much debate about their formulation before the General Assembly, for better or for worse. But they are these. What are the obligations of states under international law to protect the climate, from greenhouse gases for present and future generations. So that's what, if you go, if you want to go and listen to some of the archives of the actual proceedings, which are all available on the United Nations TV channel, they will refer to question 1 and question 2. So this is question 1. What are the obligations of states under international law to protect the climate for present and future generations? And secondly, what are the legal consequences where states have breached those obligations, where their breach has injured states, including but not limited to small island developing states, and where those injuries are to present and future generations. So this is different, for example, than what federal courts do in the United States or the United States Supreme Court. We have a rule in the United States stemming from the US Constitution that courts, that is federal courts, state courts are different. Federal courts can consider only actual cases or controversies. That's directly from our Constitution, and through common law, through decisions, the U.S. Supreme Court has fairly strongly enforced that. Although where you have a very activist Supreme Court, they seem to be reaching questions and providing a bit more advice than you would think is warranted by the no advisory opinion doctrine in the United States federal courts. But that's not the case for the International Court of Justice. Also not the case for the International Law of the Sea Court, but and I think for good reason, because there are certain common questions that do affect how nations do or should be interacting with one another, including these questions. And so it is a good thing that there is a recognized court that can lay down the law, so to speak.
So Dan, the World Court is a court, and this was a proceeding. Were the parties that participated, were they opposing parties?
Well, as I showed before, there are a lot of parties, but because this is an advisory opinion proceeding and not a direct conflict between states, there were not really opposing parties. All parties, formally at least, Nelson, were there to provide their best thoughts on the questions, and advising the court as to what they think the advisory opinion should look like. What is international law supposed to be with respect to these two questions? So, but in fact, there really were, in my view, and I'll go on to another question I think you were going to ask is, what is the difference between these two groupings? I think there were essentially two groupings here. The first grouping were nations like Vanuatu or the Maldives or Bangladesh. The majority, in fact, of the so-called lesser developed nations. They, I think you could say, fell into group 1, where their position was, yes, there are international obligations stemming from the United Nations Framework Convention on Climate Change and the Paris Agreement to the UNFCCC, the two treaties that have been negotiated over the last 31 years. the first UNFCCC in 1992, and the Paris Agreement to the United Nations Framework Convention on Climate Change in 2015. And they do form some of the content of relevant international legal principles. But the groups in Group 1 said, that's not the end of it. In fact, that's just the beginning of it, because there are other principles of international law that apply. I mentioned some of those before. The obligation of no harm, the no harm principle, the duty to uh, pay reparations or to limit damage or to compensate for damage. The duty to actually mitigate emissions rather than the procedural duties that fall under the UNFCCC and FCCC and the Paris Agreement. Those documents, those treaties provide for procedural duties, a duty of transparency, a duty, for example, to report your emissions, a duty to come up with your own voluntary plan of action, a duty to update those voluntary plans, but no firm binding obligations of performance. But Group 1 nations say, no, you actually have to do more. You need to perform. You need to act with due diligence to actually mitigate, that is, reduce your contribution to the problem. And to the extent that you have been a major contributor to the problem, well, you have a duty to clean up your mess. And you have a duty to compensate for loss and damage and to assist lesser developed nations um, to mitigate their emissions and to be able to access technology for low carbon energy generation and the whole 9 yards. But Group 2, led by major emitters, in fact, on the third day, the United States was followed immediately by Russia, and they both had essentially the same position. These are the major emitting nations and a number of others that say that the legal obligations under international law begin and end with those two treaties. And so the obligations of nations are not actually to perform, but to do your best. The obligation also is to report and to be transparent and to submit plans and update those plans. But it is, up to the nation to decide their own success in achieving what they set out publicly that they sought to do.
Were you representing any of the parties, or if not, what was your role there? Why did you go?
So, as I indicated before, I do a couple things. One, I help to run a CPR initiative and help us pursue our major efforts. But I also represent some environmental clients, and my longest standing one is the well-known climate scientist James Hansen. And he and I were contacted by the attorney for the Republic of Mauritius. Mauritius is a small island nation off the southeast coast of Africa. And Mauritius, like many of these other island nations, is very concerned that the way things are going, they're going to lose a substantial amount of their land mass to the rising seas. And of course, these island nations also suffer from a panoply of other major climate impacts, including often a change in the dramatic changes in their hydrological cycles. So we were asked to do an expert report for the Republic, for the court, And we did that in August, and that was submitted by Mauritius in conjunction with their own brief, and their brief tiered to the Hansen expert report. And his report was very, very strong hitting, including this statement warning that unless we get our act together, we could actually see a shutdown of the AMOC, the North Atlantic Overturning Circulation, over the next several decades. This is actually exceptionally important for this neck of the woods that I'm in right now, because without the transfer of heat through the various currents, including the North Atlantic Overturning Circulation, Europe would be much, much colder than it is now. Here it's fairly balmy since I've been here. You know, this is, what are we, mid December already. But you know, the temperature has ranged from 32 degrees Fahrenheit to 50 degrees Fahrenheit, and that of course is a function and part of global warming, but it's also a function of a well-functioning Atlantic meridional overturning circulation system, which brings warmth from the southern latitudes up through the Atlantic to Europe. So in any event, he warns of that happening, in fact, in the next couple or several decades, and also multi-meter sea level rise. Now, rendering the planet practically ungovernable. Now, I should say that we came here expecting or thinking, at least when we planned our trip, that he would get to stand with Mauritius and the court would be able to ask him questions, or he would be able to at least summarize his expert report. But on November 10, Mauritius had an election, and the government fell to a new government, and in the course of its reorganization, the new government decided that it would not attend these proceedings, for oral argument. But they also decided that they would not retract their existing filings. And so the Hansen, the Hansen expert report remained in the record.
What are the other scientific reports that were submitted to the court?
Well, before going there, let me say a little bit more, if I can, Nelson, about the Hansen contribution, because this will make my answer to the question you just asked more understandable. So we decided that it was really important, for a number of reasons, even though it was still in the record, for us to try to call a little bit more attention to Jim's contribution. And so in the course of these proceedings, we also decided to hold a side event press conference. And we did that, and it was, fairly well received, even though it was in the evening. And we did this on the evening of December 9th, because December 9 was the date that Mauritius was initially supposed to be appearing before the court. So in any event, we decided to hold it on that night. And then the next day, if I can show the next slide, this occurred. The representative from the Dominican Republic, in her presentations report, I want to just show this for a second. referred to it. So
You please call Dr. Torres Camprui to the podium. Thank you.
and
I
here she
thank
is.
Mr. Boni Guerrero Canto. I now give the floor to Ms. Alessandra Torres Campugi.
Mr. President, Madam Vice President, distinguished members of the court, it is a great honor to appear before you and a privilege to do so on behalf of the Dominican Republic. I will address the obligations of states in respect of the potential loss of statehood that small island developing states face due to sea level rise. By now, you have received written submissions on this point from 25 participants and heard oral argument and testimony by 19. The issue is central to these proceedings. Preservation of states, the primary subject of international law and main social form of organization, is essential to the international legal order. I will first present the facts on sea level rise and its threat to the existence or integrity of many states, and will then address the two legal questions before the court. Mr. President, I begin with the key scientific facts on the magnitude of human interference in the climate system, the causes of sea level rise, and its disproportionate impacts on small island developing states, with a particular focus on the Caribbean region. The ocean is a key element of the climate system and plays a dual role that is fundamental to maintaining the balance of such system. First, the ocean is the Earth's largest carbon sink. It is also, crucially, the largest heat sink. When energy reaches the Earth's surface in the form of heat, the ocean stores it, redistributes it from coast to the mid-ocean, swallows it to deep waters, and then slowly releases it back, much cooler, to the atmosphere. Through this process of storage and circulation, the ocean historically prevented abrupt changes in temperature, kept coastal weather mild, and made high-latitude areas habitable. Most small island developing states acquired independence when the ocean was still able to provide such protection. But the ocean's capacity is not unlimited. The day after the court registered this request for its advisory opinion, the World Meteorological Organization confirmed that, and I quote, "The Earth's climate system is out of energy balance as a result of human climate change," end of quote. The Earth's energy imbalance, also known as EEI, is considered by the IPCC to be an important metric, which tells us how much, how fast, and where the Earth's climate is warming, as well as how such warming will evolve in the future. The court can find in the record that this point was addressed by Dr. James Hansen, member of the US National Academy of Science and former director of NASA Goddard Institute for Space Studies. Dr. Hansen produced an expert report that accompanies the written comments of the Republic of Mauritius. We know from IPCC's findings that the ocean has absorbed 90% of the energy released into the atmosphere through greenhouse gas emissions between 1971 and 2010. What is more difficult to grasp is what these figures actually mean in terms of magnitude. Dr. Hansen calculated that the excess of energy trapped in the atmosphere as a result of greenhouse gas emissions is, and I quote, equal to the energy of 400,000 Hiroshima atomic bombs per day. End of quote. This is a calculation he made in 2013. 10 years later, he explains, fossil fuels emissions have grown and the Earth energy imbalance has almost doubled.
Okay, and then she proceeds to discuss how the current situation is unjustly jeopardizing the very existence of these various nation states. So in any event, by the way, am I back on the PowerPoint now, Nelson?
Yes, we're seeing in slide 11.
So in any event, we did succeed in having a bit of an oral presentation through the Dominican Republic to call the court's specific attention to Jim Hansen's expert report. And in fact, the day after that presentation by Alexandra Torres Cambrubri, she did email me and tell me that while she was presenting the material on the Hansen expert report, a number of judges were busy taking notes and highlighting things, and so she's sure that at least a number of them are really attending to that report. So then you asked Nelson about other scientific efforts, is that right?
Yeah, were there other reports submitted to the court?
Yes, the answer is that there were many of the presentations by other nations and other international groupings or international groups. Also heavily relied on some on IPCC reports, some on other scientific reports, and indeed the court itself took cognizance of 512 pages of materials directly from the IPCC, including summaries of policy for policymakers of the working group 1, 2, and 3 reports from the 6th assessment report, the summary for policymakers of the special report from the IPCC on impacts from warming at 1.5 degrees above pre-industrial and 2.0 Celsius warming above pre-industrial, and a few other reports, including one report on the cryosphere in the event of continued warming. And I'm just raising this for completeness. I was hesitating about mentioning this, but I think I need to do this. I feel obliged to note this as well. The court, and this is not a great secret, but I haven't seen it reported by anybody. The court in November, so the week before the proceedings started, announced that it had, at its invitation, it had met with a group of past and present authors of reports of the IPCC. I think it's a problem, frankly. Don't want to belabor it too much, but they met with members of the IPCC, but we don't know what was discussed. I mean, we know they were talking about climate change, but we don't know in any detail about what was said, what was emphasized. In fact, we don't even know the particular questions that were asked. unlike with respect to all these other proceedings from which I've drawn and I've been following, there was no record published of what was said. In fact, with respect to all of these oral arguments and all of the written filings, all of that is public information. But for some reason, actually I can scarcely believe it, but there was no record here, not even a summary. So I can only tell you that they did meet with a panel. I'm not a panel, with a group of lead IPCC scientists, heads of one working group or another, and so on, but we do not know what was said.
What about the United States, Dan? Was the U.S. in group 2 or as you described it, or what?
Yeah. Well, actually, before going to that, why don't we just take a 2-minute intermission so that people can write some of their questions in the chat, and then
We've got 3 questions already. I think we're short on time, so maybe we
Okay.
should dispense with the 2-minute intermission.
Okay, we'll dispense with that. And yes, I'd say the United States was solidly in group 2. That is, the United States was among the nations that stated essentially that the obligations to international law with respect to climate change for the nations are limited to those that are expressly provided in the United Nations Framework Convention on Climate Change and the Paris Agreement. And with respect to international responsibility, for example, for historic emissions, the United States, by the way, we're not the largest present emitter. We're number 2. China is number 1. But what matters with respect to impacts to the climate system is the accumulation predominantly of CO2, but also other greenhouse gases in the atmosphere. And the United States is by far still the largest historic aggregate emitter. So perhaps it's no surprise, although it's still a disappointment, that they're saying that as for the United States representative said that as for historic emissions, there's no international responsibility unless you can prove that there was an international legal obligation that came into existence way back when, and you would have to establish such responsibility on a case-by-case basis. And in any event, they urge the court to look at what states' current obligations are, because what's important now for this proceeding, according to the U.S. representative, is that clearly states have the requisite awareness that emissions are causing dangerous climate change. Now, to me, this is not to say that the role of any representatives or people from the United States was entirely bad. There was actually a person on the court who as we'll get to, who I think said something really important, although again, of course, she's not representing the United States. But here, with respect to the representation by the person from the Biden administration, legal advisor from the State Department, I personally believe that her contribution was regrettable at best, particularly when one understands or reflects on the fact that Trump, on the day of his inauguration, probably will withdraw our nation from the Paris Agreement. Now, unlike why do we think he will do this? Because he has said he will do this. And also back in 2017, the day of his inauguration, he attempted to withdraw us from the Paris Agreement then. For reasons that I think I've discussed in my blog, that turned out not to be effective until the last weeks of the Trump administration. But here, there'll be no such luck. Our new withdrawal from the Paris Agreement will be effective 1 year from Trump's announcement of withdrawal. So in that context, then, I think that there was a special obligation, well, actually on the part of all nations, but certainly by the United States, to say, actually, international law may be informed by the Paris Agreement, but it's certainly not limited to those who are currently under the obligations of the Paris Agreement and the United Nations Framework Convention on Climate Change. International law is logically and legally separate, and so you do not get out of your duties simply by exiting the treaty that you have supposedly been adhering to for the last X number of years. In the case of 1992 United Nations Framework Convention on Climate Change, for 32 years.
So were there, if the U.S. participation wasn't really everything it might have been, were there any countervailing contributions that were favorable?
Yeah, so here I actually want to zip down now to the questions from the court, because as I indicated before, Judge Cleveland from the United States, I felt that she hit, and this was very promising to me, she hit the nail on the head. Is that the expression? She asked the perfect question. So at the end, at the close, which was yesterday, of all the presentations, the court allowed, the president of the court allowed judges to ask some questions. And the parties have a week to respond. And so I thought her question was very good and very, very promising that she chose to ask it. And I thought the other questions from the other judges are good as well. So I'd like to go to that now, if I can.
La Cour.
Afternoon. Having been informed by various judges that they have questions for the participating delegations, I shall now give the floor to each of them. First, I give the floor to Judge Cleveland.
Here's Judge Cleveland.
Thank you, Mr. President. My question is addressed to any of the participants who may wish to answer it. During these proceedings, a number of participants have referred to the production of fossil fuels in the context of climate change, including with respect to subsidies. In your view, what are the specific obligations under international law of states within whose jurisdiction fossil fuels are produced to ensure protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases, if any? Thank you.
I thank Judge Cleveland. I now give the floor to Judge Slati.
Thank you, Mr. President. In their written and oral pleadings, participants have generally engaged in an interpretation of the various paragraphs of Article 4 of the Paris Agreement. Many participants have, on the basis of this interpretation, come to the conclusion that, to the extent that Article 4 imposes any obligations in respect of nationally determined contributions, these are procedural obligations. Participants coming to this conclusion have, in general, relied on the ordinary meaning of the words, context, and sometimes some elements in Article 31.3 of the Vienna Convention on the Law of Treaties. I would like to know from the participants whether, according to them, the object and purpose of the Paris Agreement and the object and purpose of the Climate Change Treaty Framework in general has any effect on this interpretation, and if so, what effect does it have? I thank you again, Mr. President.
I thank Judge Tladi. I now give the floor to Judge Uresco.
Thank you, Mr. President. I will present my question in both English and French. My question is the following. Some participants have argued during the written and/or oral stages of the proceedings that there exists the right to a clean, healthy, and sustainable environment in international law. Could you please develop what is, in your view, the legal content of this right and its relation with the other human rights which you consider relevant for this advisory opinion? And the French text is, certains participants ont fait valoir dans leurs écritures et ou lors de la phase orale de la procédure que le droit à un environnement propre, sain, juridique de ce droit. Merci, Monsieur le Président.
Je remercie le juge Uresco.
I'd like to thank Judge Oresco.
Charlesworth.
Thank you, President. My question is addressed to any of the participants in the proceedings that may wish to answer it. In your understanding, what is the significance of the declarations made by some states on becoming parties to the UNFCCC and the Paris Agreement, to the effect that no provision in these agreements may be interpreted as derogating from principles of general international law, or any claims or rights concerning compensation or liability due to the adverse effects of climate change? Thank you, President.
Okay, thanks for letting me show that. So you get a flavor of the questions, and I was especially gratified to see the question from Judge Cleveland. The need to phase out the production of fossil fuels really resides at the heart of our analysis at CPR Initiative.
So we've received some questions in the chat, and I'll combine the first two questions from Chris Harding and Jeff Suchan. Who enforces the decisions of the ICOJ? Is it a tit-for-tat duties / tariffs, or what's the mechanism for enforcement?
Okay, well, first of all, it's presumed that countries, there's a presumption of regularity that countries will want to do what international law requires. But back to the real world, yes, the enforcement of international duties, such as a duty, for example, of mitigation, is the subject of discussions among the nations, and will be before the Framework Convention and the conferences of the parties. It is the subject already of a discussion before the European Union and their determination to selectively be imposing carbon border adjustment mechanisms with respect to high embedded emission steel and aluminum products. Perhaps at some point that might be extended to chemicals. So far, they've decided not to go after natural gas or oil or coal for obvious reasons, because Europe is currently highly dependent on those imports, although they're rapidly trying to develop other resources. So yeah, it's a complicated. To fully answer the question would require me to spend a couple of hours, but suffice to say that, like the Pope, the International Court of Justice has no army.
Debbie Hill has a question. What organization or agency represented the United States?
The United States represented itself through legal advisors in the State Department and Department of Justice. And you can find all of that in public records before the International Court of Justice. I know Debbie Hill, and Debbie, I can get that for you.
John Fitzgerald's question is, can you discuss the extent to which a strong opinion from the ICJ is likely to be cited as supporting tariffs and embargoes on greenhouse gas intensive products?
A strong opinion from the International Court of Justice will be cited in my opinion, in many proceedings going forward, including what John Fitzgerald is also on our board of directors. He's vice president of our board of directors as well, and he's an attorney, so that's why he can ask such a particularized question, although it's of general interest. Yeah, I think that depending on what they say, but a strong advisory opinion will reverberate, I think, for decades at least, in our continuing and well beyond the incoming administration in the United States in considering what are the duties, including in efforts such as may be pursued by various public interest organizations, including CPR Initiative, in seeking various rulemaking or legislative changes that affect, for example, the continuing production and distribution and exportation of fossil fuels, limiting emissions from various sectors, and so on, because we will argue that this not only is required by a reasonable protective reading of US law, but also under fundamental international common law.
Don Viviani, our CPRI board president, asks if you could clarify Judge Cleveland's point. Was she suggesting maybe subsidies and emissions, or what exactly?
Not only with respect to subsidies for the production of oil, gas, and coal, but also production itself. What is the obligation of the major fossil fuel producing nations with respect to their duty to protect the climate system? I mean, she didn't come out and say, does the United States, which by the way is right now the largest producer and largest exporter of natural gas and the largest producer of oil, is it especially required to take action to protect the climate system because of the tremendous contributions to the problem that it's creating? And of course, as I indicated before, there is a duty under international common law to stop contributing to the problem and also to contribute to its solution, including cleanup of the atmosphere potentially, or the oceans. But that's my point. Her clear implication was just that the major producers of oil, gas, and coal, since oil, gas, and coal, when used as intended, is the major contributor to dangerous climate change, what are the special obligations that attach to those producers?
James Engel has a question. What U.S. news organizations and climate reporters are closely following the court on all of this? Does CPR Initiative have contact with any of these news people?
Well, first of all, I should say that we're a very small organization, and the specific answer is I have not had a chance to be following all the coverage. I mean, I do, even though I've been so busy here these last 2 weeks, I do still read the New York Times and the Washington Post. I haven't seen much there. There was a decent article in the New York Times the day before the hearings. I know that there's been some coverage in Inside Climate News. Carbon Brief is it's not really a trade publication, but it is read by many decision makers, policymakers, and also the climate advocacy community. They had a very good interview of Philippe Sands, who is the attorney for Mauritius, who got Dr. Hansen and I involved, and he outlined, I think, properly some of the major important questions that would need to be decided. So, but I cannot say that I've exhaustively been following coverage. I will say that we have some connections in the media, and so, for example, we did a press release for the Hansen side event public discussion, and we were able to get that to 101 different journalists around the world. So we have some connections, but with additional resources, it would be good. CPR Initiative would like to do a substantial more bigger outreach to major international and national media.
And just to follow up with what you just said, Dan, if any of you that are watching this presentation have any suggestions and contacts in the news media that you might be able to share with us, that would be very welcomed. Now, a couple follow-up questions from Jeff Sushan and Chris Harding that really kind of go hand in glove. Who selects the judges for the World Court? And secondly, who investigates potential corruption of the ICOJ?
Let's see. Did I stop sharing?
Yeah, we're seeing all of the participants of the.
Okay, very good. So I'm not an expert in this, but I'm given to understand that judges, the pool of judges, are those who are or have been members of the Permanent Commission on Arbitration, which is which is a non-US based, UN based panel of judges. There are 4 persons nominated from each nation that is a member of the Permanent Court of Arbitration. In any event, those are judges who are understood to have a very detailed understanding of the international system, and the Permanent Court of Arbitration is housed at the Peace Palace along with the International Court of Justice. And I believe that somehow the judges themselves select from that crew. Who polices them to guard against corruption? I do not believe that there is any outside entity that does that. I believe the court itself, similar to the U.S. Supreme Court, monitors the inherent adherence of their colleagues and to their code of ethics. And they do have a code of ethics. I mentioned some of the provisions of that code. But I also believe that in the entire history of the International Court of Justice, no one has been kicked off for cause.
Question from John Burks, who is also on our board. Are you concerned that the private meeting with the IPCC scientists may have resulted in a more conservative view of the dangers of climate change?
Yes.
Yes, okay.
I'm not apoplectic about it, but I am concerned. For example, Dr. Hansen is coming out with a paper. Drafts have already been publicly released, where he really nails down the dispute that he's been having with the IPCC over climate sensitivity. He believes that the climate system is much more sensitive to a doubled CO2. That is to say, CO2 is has a much greater long-term, that is equilibrium forcing impact on the climate system than has generally been believed. And or for another thing is that Dr. Hansen, I know a lot about his positions because I represent him and I've been reading his stuff, but I also read a number of other reports and the relevant literature. He and his colleagues have, I think, established a good reason for why we've had this global warming acceleration over the last few years, including especially in 2023 and continuing in 2024. That is a steeper rise in the rate of warming globally, and that is because of a reduction in sulfur dioxide emissions from shipping. And I believe that many scientists at the IPCC think that the cause is unknown or inexplicable. And so, I think that it would be so for a number of reasons, not just because, one scientist has some concerns. I think it would be at least important to know what was the specific advice and information that was conveyed by those particular IPCC scientists. Now, by the way, I happen to know some of those IPCC scientists from my work over the years. And I think a number of them are really good. So that's why I say I have some concern, but I am not panicked over it.
Do you know, or is it known who the scientists are that participated?
Yes. Yeah. I cited only to the first paragraph of that press release, but the scientists who were part of that group are in that full press release.
So can some of them be contacted to find out more about it?
I think so, but we're not going to do that. We have other priorities, and I'm not sure what good would be done there. I just think generally that courts, should be transparent, and it would have been good for this court to have at least published a summary, if not a verbatim transcript of what was said. I think they should have published a verbatim transcript. But I don't think it would do any use to contact individual scientists, because I'm sure none of them took verbatim notes, and then you would have different scientists thinking that different things were said. So I'm not sure what use there would be in that. I mean, that's potentially the job of some enterprising journalist, but we have bigger fish that we need to fry at CPR Initiative.
Well, Don Viviani suggests or wonders if the scientists' conversations were not disseminated, is it possible that this was done to shield them from their own countries?
Yes, I think that possibly is possible. There are some, scientists from some nations who currently or predictably might have governments that would not take kindly on some of the scientists having given some of the information that they did, particularly where one nation or another, one current or incoming government or another is heavily influenced by or captured by fossil fuel interests. So yeah, I do understand it. On the other hand, I don't think it was just that justifies that kind of extraordinary procedure, in my opinion.
Mike McCracken asks, what is the decision-making framework in the court that is called upon to use? Is it based on risk, for example, or high confidence, whatever? What is the decision-making framework the court is
understand.
called upon to use?
I understand. It's a great question, Mike. I don't think that there's any specific decision-making framework that they need to utilize. I think they're going to make it up as they go. They certainly have staff attorneys assisting them. You saw that a number of the judges had very pointed questions. They're thinking a lot about these issues. By the way, I more generally, in answer to Mike McCracken's question, I don't envy them in having to decide this case and come out with a coherent advisory opinion, in part because of the breadth of the questions that were asked. Usually seeking an advisory opinion, at least in my understanding, before the World Court, the General Assembly would be well advised, or the Security Council. The Security Council also can submit a question to the International Court of Justice, Security Council of the United Nations. Would be well advised to draw the question quite narrowly. But here, really, they're asking for the court to consider not only the Paris Agreement and the United Nations Framework Convention on Climate Change, but the entire edifice of legal principles under international law, and apply those with respect not only to small island nations, but to any highly vulnerable nation. I had edited that out when I gave my distillation of the questions, and to consider what are the appropriate legal consequences, which is asking a lot, since they don't have individual cases of actions by individual nations before them. So I think probably the first order of business for the court would be to cut those questions down a little bit into manageable chunks, and then to consider what are the most important questions that they need to address. And in doing that, I think that the court would be well advised to attend to the actual facts of the matter. That is to say, are nations in general honoring their commitments in the breach, that is, failing to honor their obligations under the UN FCC and the Paris Agreement? And if so, I mean, if we are honoring all our obligations under the two treaties, then perhaps there would not be such a crying need to consider broader principles of international law. But the truth of the matter is that we are honoring, including the Paris Agreement, including especially its intent, we're honoring that in the breach, and we are not on our way to slashing emissions, no less cleaning up excess, the overburden of excess CO2 and methane and the rest of the Kyoto 6 greenhouse gases in the atmosphere. We're going in the wrong direction still. And so in that circumstance, I think the court could say that we need additional sources of law to protect the planet, and so honor at least the intent of the United Nations Framework Convention on Climate Change and the Paris Agreement. But we will see. And by the way, I don't expect them to turn it around in a week. I don't expect them to turn it around in a couple of months. I think it'll probably take them 4 months to a year to come out with their opinion.
Well, I think we've come to the end of our questions for now. Just a second. John Fitzgerald had a follow-up question. Should income from tariffs and embargoes on greenhouse gas intensive products be dedicated in part to pay for reducing emissions and removing GHGSs?
Well, that's a pretty specific question. And I can see arguments made by states in both directions. This is not a question I think that the court will wrestle with, of course, but I think I think it's possible. On the other hand, states may say that they need to recover those for the Treasury or distribute it to impacted industries disadvantaged by cheaper manufacturing outside the country where there are no controls or lesser controls over, for example, greenhouse gas emissions. So I think, it's a question of design, and, I can see arguments on both sides. Before we go, Nelson, could I just go back to the PowerPoint to tell people how they could get
Sure,
engaged?
yeah.
Okay. Whoops. Sorry, I didn't mean to do that. By the way, I will be writing about those 4 questions that were asked and how I think that they should be resolved by the court. And of course, I'm also going to, I write a blog for our supporters. This is at cprclimate.org/blog, and they're all there. And I attempt to provide some analysis, hopefully in understandable language. And then, so I will be covering the final decision. And then the way that people, if you're not already with us, can be apprised of what we're doing is you can go to cprclimate.org and make a donation. Although for people who are not able to make any donation, you can still sign up to get on our list. So anyhow, I just wanted to say those 2 things, Nelson, and to say that I really appreciate the opportunity and the interest of everybody. And thank you, Nelson, for helping out for today's session. And Kaylee Martin, who was helping in the background, thank you very much for your work. And we'll see you all down the road. Thanks very much.